Welcome to Facts or Frauds.
Calling case 2024-2849 DC, Mary Alderink versus Stephen Smith. Today is Monday, October 28, 2024 at 9:56 a.m.
Court will note the appearance of Ms. Podolsky on behalf of the plaintiff and defendant appearing in pro per. This matter is before the court on the plaintiff's motion for temporary custody, support, and parenting time. Ms. Podolsky.
Thank you, Your Honor. As we stated in our motion, the parties have one minor child together. He is 3 years old. Parties were in a dating relationship until about August 14th of this year, at which time that relationship ended. And since then, the defendant has had no parenting time with the minor child. My client has offered him parenting time, but he has not availed himself of it. The defendant does have a history of drug use, his drug of choice being methamphetamines. My client has witnessed him using methamphetamines. He's witnessed him holding paraphernalia in the party's home. He is currently not working. We did identify his last place of employment in our motion. He was terminated from that employment after refusing to participate in an employer-mandated drug screen. And he has a March of 2024
objection
case.
Hearsay.
In the 10th District Court for possession of drug paraphernalia. We do believe that he may have other criminal matters outside of Calhoun County and even outside of the state of Florida. And we have concerns that he doesn't have a valid driver's license, but in any event of using substances and transporting the minor child. We do believe that it would be appropriate to issue an order of sole legal and physical custody to my client. She has been the sole caretaker of the party's minor child since birth. She is a fit and proper individual to care for the party's minor child. And she is proposing a parenting time schedule. That would be a supervised visitation schedule to occur on alternate weekends, supervision to be done by the defendant's mother. And that if defendant did fail to attend a visit or left early, that his mother could continue that visit, as she is an important person in the minor child's life. My client is not trying to take the child's paternal family away from him. She's just simply trying to keep the minor child safe and knows that defendant's mother can do that. So we're also asking that if defendant does appear at one of those visits under the influence, that he must leave immediately. And his mother has agreed that she would terminate those visits if that happened. Because of the drug use and the significant history, we're asking that the defendant undergo a substance abuse evaluation, a psychological evaluation, and follow the recommendations of both, and with those evaluations provided to our office, as well as participate in drug screening prior to parenting time. We did outline my client's income information in the motion. We don't know if the defendant has gotten a job since we filed this matter. However, we do believe that he could work. He could work 40 hours a week and he could go out and earn $20 an hour, but would have to participate in employee mandated drug testing and be able to work. So we are asking that the court impute him at $20 an hour, 40 hours a week for the purposes of child support. Thank you.
Thank you. Mr. Smith, what's your response?
Mute.
Got me muted.
Okay, we can hear you now.
Can you hear me?
Yep. Go ahead, sir. What's your response?
I have filed my Hague application to your office, Your Honor. And have you received that?
No, I have not.
I wasn't served papers until the 18th of this month, and today's the 28th. I saw that the papers were drawn up on the 2nd of October. If you haven't received that, it is in the mail. But I, because of time, I can go over the Hague application that I have currently, and with my LLC on the articles of organization, that creates this address as my home state, and I'd like to apply that. My home country.
Sir, I don't care. Just respond to the motion. I don't care about all that other stuff.
That is my response to the motion. Before we further this custody battle and waste more time of the court, the Hague application takes precedence, and I would like that applied.
The what application?
The Hague application, Hague Convention application.
I have no idea what you're talking about, sir. I know what the Hague
All right.
Convention is, but I don't know what you're talking about having filed because I haven't seen it yet. So I'm asking you
Well,
what.
the court has a file of it, and now I have sent another file to you. I have one in front of me. Obviously,
I'm
not
asking
something
you
that I
to
can
tell me,
submit again.
sir. I don't have it in front of me. I'm asking you, giving you the opportunity to tell me what you filed.
Okay. All right. Bear with me 1 second. So the Hague application is time and place and circumstances of wrong removal or retention. 3 p.m. Wednesday, August 14th, mother dropped off father at Center Stage Dance Studio. Plaza, for father to complete moving furniture. Upon completion, was led to believe that the mother all would be joining plaintiff mother and grandmother for dinner that evening. Mother explained a 24-hour break period from the conflicts of raising a young boy. Time spent at defendant's Paris address. Factual and legal justification for request. Since birth on 11/1/20, habitual and sole residence has been my address at This is 5 continued. So time which, okay. He spent time at parents' house for a 24-hour period. Opportunity for her parents to watch the minor child while the mother continues to elongate separation period from father and has since cut all communication with the plaintiff father. Based on the above testimony declaration, I'd ask that the court to see that it's necessary to honor the application of the Hague Convention and rule for the minor child to be returned to his only known address. Plaintiff would maintain an open communication policy with the defendant and pray, God willing, we can, as adults, continue to raise a very special boy without further needing the time of the court. Proposed arrangements for return. His mother would open the lines of direct communication and make arrangements for the first day off following notice. Other persons and additional information. Jim Alderink, the grandfather, same address. Kathy Alderink, grandmother, same address. Mary, the mother, same address. Other relevant information. Mother has removed minor child from established residence. Mother has also severed all line of communication except that through specifically the grandfather, Jim Alderink, via text mostly. Plaintiff father would like to remain open-minded to the mutual arrangement between parties involved, understanding the importance of responsibility and not limiting the time of the court.
Okay, anything else, sir?
That is the end of that application.
Okay. Well, in this particular matter, the court notes that based upon the pleadings and the argument that the parties did separate on or about August 14, 2024, that the child has been in the care of the plaintiff since that time, and the defendant has not had any parenting time since then for various reasons as stated by the plaintiff. The court is going to therefore continue the status quo and grant to the plaintiff the custody of the minor child. The court will, in this matter, set support pursuant to the child support formula. Ms. Podolsky, what I'm going to do at this point is I don't know. I'm going to impute income to him as based upon what his income was with the Liberty Commons apartment when he was last working at that place. The court would grant to the defendant supervised parenting time, supervised by the paternal grandmother on basically alternating weekends from starting on November 8, 2024 at 6:00 p.m. to Sunday at 6:00 p.m. that he would have his midweeks on starting on November 6, 2024 from 4 to 8:00 p.m. and alternating holidays based on the front of the court holiday schedule, and that those would be supervised as stated. If in fact the defendant were to appear to exercise his parenting time, and if he is under the influence in this particular matter, that the parenting time would end at that time whenever he were to show up, if he is in fact under the influence. Ms. Podolsky, you can prepare that order and submit it under 7 day.
Okay, thank you.
Thank you. You're free to go. Have a good day.
Thank you. You as well.
Your Honor,
Yes.
could you refer me to the next, my appeal for this judgment?
Your what?
Appeal to this judgment?
You can appeal anything you want, sir.
Right. So would that go to Hallacy?
No, it would go to the Michigan Court of Appeals.
Okay. Thank you.
Okay, thank you.
You can't fix stupid.
And thanks for hanging out with us on Facts or Frauds. Make sure you hit the thumbs up button, you're subscribed, and ring that bell. Also, leave a comment in the comment section. Tell me what you think. And a huge thank you to all of our Facts or Frauds channel members. If you'd like to become a member, click on the link in the description or click join right next to subscribe. And if you're still hanging out, thank you. I appreciate you all. Hit that thumbs up button, make sure you're subscribed, ring the bell, and leave a comment in the comment section. Tell me what you think. Till next time, I'll see you soon.